Thank you, Dr. Naftali. We'll now go to rounds of questioning. We each have 5 minutes to ask questions of the witnesses. I'd like to say at the outset that there have been at least one, maybe two, who've questioned the title of this hearing, which includes the words, "When the president does it, that means it's not illegal," all in quotes. Who were we quoting? Richard Nixon. Who could we have quoted? Perhaps Donald Trump, who said presidents have to be given total immunity. They have to be allowed to do their job. And it turned out that was his defense, which he brought before the court in the Supreme Court decision, which we're questioning. My colleague, Senator Kennedy, made a point that there's still the authority and right of a prosecutor to prosecute criminal activity of a president in certain circumstances under this decision. But as he went on to say, they have to prove beyond a reasonable doubt. I'd like to add that there was also a part of this decision which limited the use of evidence by prosecutors. And that was noted not just by me, but certainly by Amy Coney Barrett, a Trump appointee to the Supreme Court. Here is what she said. Before I quote her, the holding was a bridge was too far for her. She argued that, quote, "The Constitution, of course, does not authorize a president to seek or accept bribes. Yet excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution." Professor McCord, as a former prosecutor, would you walk us through what prosecutors need to establish to successfully secure a conviction, and exactly how this prohibition on evidence in the Trump versus United States case would prevent prosecutors or harm their efforts to do so?
Yes, a prosecutor, of course, to prove any criminal case must prove beyond a reasonable doubt every element of the offense charged. And to do that, they introduce evidence into court that establishes those elements and argue to the jury that the elements have so been proven. By hamstringing a prosecutor, even in a prosecution that the Supreme Court has now told us is possible, a prosecution for unofficial acts, purely personal acts, by barring evidence of official acts in those prosecutions, that severely hamstrings the government, as Justice Barrett pointed out in her dissent to that part of the court's opinion.
Justice Barrett went on to say, allowing into evidence official acts for which the president cannot be prosecuted, the argument that they may prejudice the jury is already addressed by the rules of evidence, which, quote, are equipped to handle the concern on a case-by-case basis. Do you agree with that?
I agree with that, Chair Durbin, and that includes when evidence might be more prejudicial than probative.
Mr. Lacavara, you have noted that it's impossible to find the basis for presidential immunity in the wording of the Constitution. Would you like to address that to those who are originalists?
Yes. This is one of the great ironies of the decision by Chief Justice Roberts. It's not just a question of not being able to find authority in the text of the Constitution for any form of immunity, absolute or even qualified, for commission of crimes by a president. The Constitution expressly says the opposite. The president is subject to impeachment. Indeed, Article 2 is quite explicit in saying the president and all other officers in the executive branch are subject to impeachment. And then the impeachment clause, this is in Article 1, Section 3, about the role of the Senate in trying impeachments, says judgment shall not, in an impeachment, shall not extend beyond removal from office, so that unlike in Parliament, where a penalty such as death could be imposed by Parliament, only upon conviction is a official such as the president removed from office. But then the text goes on to say, but the party convicted, that includes the president, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. I think it could not be fairer or more obvious that the framers of the Constitution intended that a president, whether or not impeached and removed, is subject to the normal course of law, as the text said, if his conduct, his official conduct, was not only impeachable or possibly impeachable, but also a violation of criminal law.
Thank you. I want to close by referencing a statement made earlier by my friends on the other side of the aisle. Never should anyone interpret these hearings as an invitation to violence against anyone, period. A Supreme Court justice or any person involved in our nation's affairs and public interest and public policy. Holding a hearing on a Supreme Court decision is almost routine in this committee. The fact that we've done today, I think history will judge, is the right thing to do in light of the gravity of this decision. And secondly, questioning the ethics of the Supreme Court happens to be our responsibility under the Constitution, Article 3. I think we should continue to do that and not be questioned on our motives when we do. Senator Graham?